All right, good afternoon. I'm Judge Steinlage. This is Division 2 of the Coconino County Superior Court. This is the time set for hearing, cell hearing in State of Arizona versus Adam Smith, CR 2023-00379. I'll turn it over to the attorneys to put your appearances on the record.
And good afternoon, Your Honor. Daniel Noble for the state. Also present on Zoom is the listed victim in this matter, and also present in court is a representative from Victim Witness Services.
Thank you.
Good afternoon, Your Honor. Greg Parzik, ordered by this court to appear and represent Mr. Smith, who is present and in custody. I do have something to say before we begin.
Go ahead.
Judge, I've made numerous attempts to talk to Mr. Smith. I've been blocked from communicating with him at the jail. I again tried to talk to him just briefly to explain the situation, try to explain to him the severity of what's about to occur. He's refused to talk to me and has pretty much demanded I not represent him. I'm sure this court is well aware of that. So at this point, Judge, that's where I stand. Judge, I am not going to proceed unless the court orders me to proceed given his situation.
All right.
May I please proceed pro se, Mr. Steinlage?
You may not. You are currently, the court has previously deemed Mr. Smith not competent but likely restorable. At this particular moment in the case, the court is not going to consider allowing you to represent yourself, Mr. Smith.
Are you aware that you're a defendant in a federal matter, Mr. Steinlage? Case number CV 2608072.
Mr. Parzik is ordered to represent you in this matter, and at this time,
Mr. Steinlage, I am filing injunctive relief against you for trying to voluntarily medicate me based upon Dr. Pardee and Dr. Linsky's perjury. Are you aware of this, Dr. Mr. Steinlage? This is on the federal PACER.
Mr. Smith, I really want to be able to keep you in the courtroom so that you can be here for the proceedings. But if you don't just do basic things such as let the court speak when it's the appropriate time and, conduct yourself in a way that allows you to be in the courtroom, I'm going to have to order you to be taken out of the courtroom. Now, I did, as your attorney suggested previously, make arrangements for there to be a separate room where you can watch the proceedings, but I don't really want that for you. I really want you to be here and to be able to see what's happening in the actual courtroom and be part of it in that way. I'm not allowing you to represent yourself at this time. I can't allow you to do that yet at this time. At a future proceeding, that may be appropriate, and if we get to that point, the court will be happy to consider that at that time. But I cannot, while we're in the middle of Rule 11, allow you to do that.
Can Luke McKee represent me instead of Parsec? Parsec has a conflict of interest?
Absolutely not. Absolutely not. That's not even a person that's an attorney. So,
under rules of criminal procedure, I think it's 6.3, that a paralegal may represent me of my choosing. I think the law is...
the court's going forward. The court is going forward with court-appointed counsel, Mr. Parzik, today. So that's the court's decision. I do need to read the victim's rights advisory in this case. If you are the victim of a crime with a case pending before this court, you're advised that you have rights to justice and due process under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, and to a prompt and final conclusion of the case. You have a right to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who's been convicted of causing your loss. If you've not already been provided with a written statement of all victims' rights, you may contact the Victim Services Division of the Prosecutor's Office to obtain one. Previously in this matter, the court, based upon contested Rule 11 hearing, the court made a determination that Mr. Smith was not competent, likely restorable based upon the evaluations of Dr. Pardee and Dr. Linsky. That finding was made, I believe, on January 8th of 2026, and the court ordered Mr. Smith to the Yavapai Restoration to Competency Program. At that time, and the court issued specific orders to that effect the following day, on the 9th of January. The court notes that Mr. Smith was admitted to that program, I believe, on January 21st of 2026, and the court received the final report from the Yavapai Restoration to Competency Program on February 3rd of 2026. That is the report that was filed by Dr. Stewart, the psychologist there at the program, indicating that Mr. Smith had refused to participate in the program up to that point. The court has re-reviewed that report since our last hearing. The court also received the state's motion for a cell hearing on February 13th of 2026, and the court has reviewed that. Before we move forward in the case, are there any stipulations between the parties that need to be placed on the record for anything?
Yes.
None from the state, Your Honor. State's representative, Your Honor.
No, Your Honor.
Yes.
All right.
Dr. Pardy has committed perjury. She said Knights
All
of
right.
Templar, not
It-
Ordo Templi
It's a,
Orientis.
it's a stipulation, Mr. Smith. A stipulation means that the parties agree and are putting it on the record, not something that's in dispute. In this case, the court notes that the state has the burden of proof in the cell hearing by clear and convincing evidence. The court notes that the case that is at play in this case is Cell versus United States, 539 U.S. 166. That case was adopted in Arizona under Cotner versus Lusky, 243 Arizona 188. The court notes that in Cell and in the Lusky case that it's recognized that an individual has a significant constitutionally protected liberty interest in avoiding the unwanted administration of antipsychotic drugs. That's where the court begins going forward in this. In this hearing, the court notes that there's a 4-factor test that the court's required to go through. Following Cell, an order for forced medication of a defendant with antipsychotic medication to restore competency requires the state to establish 4 separate factors, each by clear and convincing evidence. First, they must establish an important government interest that's at stake in prosecuting the defendant on the offense charged. Secondly, that involuntary medication will significantly further those state interests, meaning A, that it's substantially likely that the defendant will be restored to competency, and B, that it's substantially likely that the side effects will not significantly impair the defendant's ability to assist in their defense. Third, they must establish that involuntary medication is necessary to further those interests, and that there are no less intrusive treatments that are likely to achieve substantially the same results. And then fourth, the administration of drugs is medically appropriate in the patient's best interest in light of their particular medical condition. So that's what the court has to examine here. And with that, did either party have any initial statements that they wanted to make, or can we get to the presentation of witnesses?
And the state's has no initial statement, and so it would go to the first witness, Dr. Alinsky, unless Mr. Parsik has anything.
No, Judge, I agree with, I've reread both of those cases and additional others, so I'm well aware of the 4 factors we're going to be talking about.
All right, I had no doubt of that, Mr. Parsik. And then Dr. Alinsky, at this time, I'm going to place you under oath. If you could take yourself off of mute for the hearing. And then if you'll raise your right hand, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead and put your hand down. And at this time, if you'll please just state your full name for the record.
Christopher Linsky, MD.
All right, thank you. And at this time, I will turn it over to the state. If you give me just 1 second. All right, and you may proceed with your direct examination of Dr. Linsky, Mr. Noble.
And thank you, Your Honor. And Dr. Linsky, do you work at the Yavapai Restoration of Competency Program?
Yes.
And what is your role there?
Currently, I am the psychiatric provider for individuals involved in the Restoration to Competency program. I took that position in late October of 2025. Dr. Collins had been the prescriber there, but he became ill, so I am at least filling in for him for now until he hopefully can return to that position.
Okay, and I think you touched on it with that comment. So the licensed prescriber, so you're the psychiatrist on duty who prescribes medication there?
Correct.
And also, you've also previously had Rule 11 training as provided by the Arizona courts.
Correct.
And you've actually testified before in this case regarding competency. Is that correct?
Yes.
Okay. And as a psychiatrist at the Yavapai Restoration Program, what are your duties as it applies there?
Typically, I meet with individuals on a weekly basis relative to their progress with medications in advancing through the Restoration to Competency program. I complete staffings with the counselors and the psychologists working with individuals there on didactic training. I work with the nurses to review lab results and tests for individuals there. And then lastly, I will sometimes prepare reports for the court relative to progress of individuals in the restoration program.
And I think you mentioned it or touched on it briefly. So meeting with the counselors and other providers there, that helps you have an informed decision about the patients there that you're working with?
Yes.
And also how they're progressing. And you said didactic, so would that be the restoration of competency coursework as well?
Yes, they use different workbooks and tools to help people advance the program to ensure that there is a base of competency relative to the factual portion of competency restoration.
And did you also work with Dr. Stewart, who was the psychologist at the Restoration to Competency program?
Yes, Dr. Stewart is a psychologist there. He was gone for about 4 weeks because he himself got separately ill, and Dr. Margerson covered for him briefly, but Dr. Stewart is the primary person who has returned, and I do work with Dr. Stewart currently.
And so he authored basically a report, but in that report, he based a lot of that information off of those staffings he had with you and other people that you were participating in staffings with as well.
Yes.
And generally, how does just generally how does the Restoration and Competency program work there in Yavapai?
The restoration is housed at Yavapai County Detention Center. There's a dedicated wing for participants in the program to be housed. People in the RTC program generally are seen by their restoration to competency counselor at least once a week, sometimes twice a week, to review the specifics of their case as well as the more general aspects of our legal system from a factual standpoint. They meet with the psychologist separate from that, typically on Wednesdays, 1 day a week as it were, just to review their progress. They're usually seen by the psychiatric provider. In this case, it's me. Typically every 2 to 3 weeks. In some cases, we'll meet with people weekly to see how the medications are impacting them positively or negatively in the event there are side effects. The didactic portion or teaching portion is based on a workbook that people go through with the counselor, and then we use a pre-test and a post-test as well as the MCAI to assess their overall status. In addition to that, frequently there are other cognitive tests such as what's called the MOCA, which is an overall assessment of cognitive functioning, and sometimes the MMPI. Those are psychological tests that I don't administer, the psychologists do, that give the team a framework in terms of areas of strength or opportunities for improvement. So it's a multi-pronged approach focused on didactics as well as medications when needed.
Okay. And so that is the program that Mr. Adam Smith was in while he was at Yavapai Restoration and Competency. Is that correct?
Yes, he was there relatively briefly. I do not have the specific dates, but it was the date range of January 25th, roughly to January 30th or 31st.
Okay. And so I think you said earlier, either 5 days or possibly even 6 days.
Yes.
Okay.
That's my recollection. I was looking for the specific dates, and I don't have them readily at hand, but it was relatively brief, a week or less.
And so while he was there, did you meet with him?
Yes.
And how did he do while he was there?
He struggled. It was a difficult place for him to be. He chose to functionally be on perhaps a hunger strike while he was with us. He did not eat. nor drink. I think he was only observed drinking on one occasion that was reported to me by an officer, despite having access to food and water. When I met with him, he did not interact with me. He was brought to me about once or twice a month. I go to Yavapai in person. The other 2 weeks, I'll meet with people telemed, such as this. And Mr. Smith refused to come. The officers were very concerned about his basic safety in terms of eating, so they brought him down, and he was in very heavy restraints. He was on a rolling stretcher, and he did not respond to me. He did not talk to me. I could see him and visualize him and shared with him my concerns. I asked the officers to take him back to the nurses, and as soon as he got back to the nurses and was unrestrained in a cell, supposedly he was able to get up straight away, and that was the one time he was seen drinking water from a sink. That was reported to me.
So previously he was refusing to drink or eat, but then again, later on, it was reported to you that he was in fact drinking from sink.
Correct, and I'm pretty sure that was day 3 of his stay with us. So if he was admitted on or about the 25th, it wasn't until the 28th that he was observed drinking water.
And so with Mr. Townsley, was he the counselor?
Ethan Townsley, yes, Mr. Townsley was the counselor.
How did you do in those sessions with Mr. Townsley?
As it was reported to me, while I was not present in those sessions, he did not interact and he declined to meet with Mr. Townsley.
Yep. And just so it's clear, Mr. Townsley would be doing the counseling, but talk about the legal structures and legal rights as well. So he was refusing to participate in that portion of the program.
Correct.
Okay. While Mr. Smith was there at Yavapai Restoration to Competency, what were the diagnoses that you were working with or trying to treat?
The larger diagnosis was termed in the chart there as schizophrenia spectrum disorder. Basically, that includes the wide range of psychotic disorders present in our diagnostic manual. In particular, Mr. Smith appears to have a diagnosis most consistent with delusional disorder as opposed to true schizophrenia, though it was referred to there as schizophrenia spectrum disorder, acknowledging that it's not entirely clear which of the psychotic diagnoses would best fit his presentation.
Okay, and I'm just reading Dr. Stewart's report. It does reference a psychotic disorder. How does that differ from the delusional disorder?
Psychosis is one of 4 different domains. 1 is hallucinations, such as visions and voices. 2 is delusions. Delusions are fixed false beliefs that cannot be challenged. There's disorganized speech and disorganized behavior. So delusions are a subset of psychosis, and so psychotic disorder basically means that one of those areas is impacted. Schizophrenia is a specific type of psychotic disorder with prominent delusions and hallucinations. So even though the disorders sound different, they're all very similar, and they're different nomenclature for very similar presentations.
And so how are they treated differently?
Generally, no. Most psychotic disorders are treated with medications termed antipsychotics. Antipsychotics basically work on neurotransmitters and brain systems to help decrease the intensity of psychotic experiences, such as delusions or hallucinations, and they are generally the cornerstone of treatment for psychotic disorders, whether they're schizophrenia, delusional disorder, schizoaffective, or some other type of psychotic disorder.
And what medications were prescribed at the time to treat Mr. Smith?
He was prescribed the medication Haldol, 5 milligrams twice a day, Cogentin, 1 milligram twice a day, and those are the only 2 medications, yet he did not take the medications throughout his stay at Yavapai.
Okay. And so, and those were specifically to treat the delusional disorder and the psychotic disorder that you mentioned previously?
Yes.
And so how does the Haldol work?
Haldol is a medication that's been available clinically for over 50 years in our country. basically it's a medication whose mechanism, that means the way it biologically works, is entering the body, going into the brain, and blocking the effect of dopamine. Our brain has about 100 billion cells in it called neurons, and they communicate with each other with the substances that are naturally occurring molecules called neurotransmitters. Haldol makes the impact of the neurotransmitter dopamine less powerful in the temporal lobe. The temporal lobe is the collection of neurons sort of behind our ears, and it appears as though clinically the understanding is that as we decrease the intensity of dopamine in the temporal lobe, the intensity of delusions and hallucinations generally tends to improve rapidly once this medication is administered.
Okay. And so how would that help him in rendering him competent?
The area that appears to be the largest part of concern for Mr. Smith is incapacitation of competency due to delusional beliefs of persecution and delusional beliefs of different types of conspiracies or societal beliefs that are putting people at danger, making it impossible for him to appreciate his own best legal interest in defending himself in this case. So the idea clinically is to decrease the intensity of those delusions with a clinical expectation that rational thinking will return such that he can work with his attorney rationally to defend himself in this case.
And so would that be in his best interest then? At least medically speaking?
Yes, to treat someone for a psychotic illness would be in his best interest, yes.
Are there any side effects to Haldol?
Yes, Haldol can have some side effects, sometimes very serious side effects. Haldol, for the most part, is tolerated well, but it can lead to, in quotes, nuisance side effects, close quotes, such as constipation, dry mouth, urinary retention, and sedation. Typically, these are relatively minor and not of any marked significance. They usually resolve quickly and can be ameliorated with different pharmacologic or diet interventions. There are more serious potential side effects that are quite rare but potentially serious. In some individuals, Haldol can cause a movement disorder called tardive dyskinesia. In some cases, it can cause a muscle disorder called neuroleptic malignant syndrome. And while these are very rare, perhaps less than 1 in 10,000, they are still possible and they can occur with this medication.
And so those side effects, are they just more movements? Would they affect him? Are they severe movements or are they minor movements? If you could explain that.
Well, there are 2 types of movement disorders, actually, to be more clear, and I could go into specifics because it's actually pretty interesting, but Haldol, when it blocks dopamine in the temporal lobe, it also blocks dopamine in another part of the brain called the extrapyramidal nuclei. And when it blocks dopamine there, which is infrequent, it can cause a feeling of restlessness or muscle stiffness that is mild and transient. That is one of the reasons cogentin is also typically given, because it tends to decrease the sense of restlessness or muscle stiffness. And that type of muscle disorder is called EPS. It stands for extrapyramidal symptoms. And EPS can be easily treated with cogentin and is generally seen to be very mild. The more serious one of tardive dyskinesia could either be mild or it could be severe. It usually takes many years to onset. People usually have to be on Haldol for 5 or more years for this type of disorder to present, and it would be very unlikely for a short-term dose of Haldol to lead to tardive dyskinesia. And those movement disorders are generally mild. In very rare cases, they can be severe, but for the most part, they're relatively mild.
You did that to Carlos Silva, though. He's now dropping things on the pod.
And so talking about Haldol, you mentioned that he was prescribed 5 milligrams. How many times a day was that?
Twice a day.
And is there a therapeutic range of doses that you would recommend that he be prescribed?
The therapeutic range generally for schizophrenia, which is a different type of psychotic disorder, is any place from 5 to 20 milligrams. With delusional type disorders, benefits have been seen up to 40 milligrams. That is very much the upper end of dosing. Most people that receive the medication Haldol and benefit from it are in a dose range of 10 to 20 milligrams a day, though for delusional disorder in particular, doses up to 40 milligrams have been utilized with benefit.
And to your knowledge, are there reasons why you would go beyond 40 milligrams?
No, that would not be a safe or appropriate use. There's no evidence I have that the medication's been looked at above that dose for individuals.
And you mentioned cogentin. That was prescribed to Mr. Smith. Is that correct?
Yes.
And that was 1 milligram twice per day?
Yes.
And you mentioned, why was that prescribed?
That was prescribed prophylactically in the event that Haldol caused any degree of muscle stiffness or restlessness, so that would minimize the risk of discomfort for him.
Okay. And is there a therapeutic range for that cogentin?
The maximum dose of cogentin is 8 milligrams a day, though it is rarely prescribed over 4 milligrams a day.
And so you mentioned that was for the muscle movement. Is there anything that would be specifically for tardive dyskinesia, or is that something just completely separate?
No, unfortunately, there's no prophylactic medication. There are medications now to treat neuroleptic malignant syndrome. They've been put on the market in the last 5 or 6 years. Terbinazine, I think, is the name of one. Usually those are only used once tardive dyskinesia presents. Again, it's a relatively, it's not even just relative, it's a very rare side effect, but there is now a treatment for that disorder.
Okay. So you mentioned those types of medications, and so specifically the Haldol, that was prescribed to him to take voluntarily. Are there any other means to introduce that to the body?
Haldol is available as an oral or an injectable form. That is one of the reasons that we would sometimes prescribe it. In the event that we're a sales hearing, it would be easier to transition to the option for an injectable form of Haldol.
Okay. And that's why you're recommending that here today?
Yes.
Are there any other similar medications to Haldol that you would recommend to be prescribed?
There are medications that, in my opinion, are preferred over the Haldol. The unfortunate thing about them is that they are not available as injectable forms of medications. Medications such as Risperdal, Seroquel, Abilify, Zyprexa would be preferable because their risk of movement disorders and tardive dyskinesia is less even than Haldol, which is already pretty low. With individuals that are in the RTC program under a CELS, frequently we will start with Haldol, ask if we can transition, hopefully when people start to feel better, to a more preferable medication with less side effects. But those are usually seen more as a voluntary option, engaging the person in treatment. So we'll usually start with the Haldol, hopefully make some headway into psychosis, so that we can clinically convert over to a more preferred option, which is less likely to have side effects long-term and short-term. So there are multiple other options in addition to the Haldol, though Haldol is the only one that's available as a fast-acting injectable form.
Gotcha. And for today's hearing, is Haldol the only medication that you're recommending for the purposes of forcible medication, or do you think those other medications would be appropriate?
If the court were to include it for forced medications, the 3 medications that are generally part of the approach would be the Haldol, as it's injectable and oral, the cogentin, as it's used to prophylactically address any muscle stiffness, and we usually would want to include lorazepam or Ativan. That was not written in his initial orders, but it is generally added to the regimen as it makes the Haldol more effective. It generally tends to be a muscle relaxer to decrease the side effects of it. It's also a medication that can lead to a degree of sedation, so it's typically only given at nighttime. So a typical regimen might be Haldol and cogentin twice a day, plus lorazepam at nighttime to assist with any muscle stiffness in the evening and to assist with sleep.
Okay. And what dose would the lorazepam be provided?
The maximum dose of lorazepam is 12 milligrams a day, but we rarely would use over 2 milligrams a day as a single dose. Okay. With a CELS type hearing, we would also typically look beyond those meds once the individual improves, asking about using other meds, but those would not necessarily need to be included in a court order because we would want to engage the individual with making some choices about other medications. So there's a chance that they might be offered Risperdal or Seroquel, but that would not necessarily be part of a court order because it would be part of more a therapeutic approach where the person can consent to medication trials of their own choice.
Okay. And so that's not part of what you'd be requesting here today?
Correct.
Okay. And so with the lorazepam, are there any, that helps make the Haldol more effective, but are there any known side effects to that?
The biggest side effect is it causes sedation, and it can, for the elderly, increase fall risk because it can make people unsteady on their feet. For a younger person, such as Mr. Smith, that is generally not seen as a risk. Long-term exposure to lorazepam, such as over 6 months, can, in about 5%, lead to a degree of risk for physical dependency. Again, very rare, but it can happen. The foreseeable side effects would be very few. Most people do not complain of it. And if someone were to have any degree of physical dependency on it, the medication is usually discontinued slowly in order to decrease the risk of any kind of physiologic discomfort should that happen. But again, it's less than 5% per my understanding on exposure over 6 months.
Okay. So you talked about all those side effects for those 3 drugs, medications. And does the benefit of those medications outweigh those risks and side effects that you discussed previously?
Yes.
And so together, would those medications be in Mr. Smith's best interest in that making him competent?
Yes.
How will affect my long-term memory affect the...
And how would it help him in participating with his a counsel or whomever he chooses?
The intent of the medications would be to address the underlying and fundamental issue that's impairing his competency, which is psychotic thinking, delusions, and psychotic reasoning. In treating psychosis, the overwhelming clinical assumption would be that as psychosis improves, his ability to rationally appreciate his situation and make reality-based decisions with his legal team would allow him to proceed through this legal case with his best interest in mind.
Okay. And so you mentioned these medications being prescribed voluntarily and then also here today being forced injection. Are there any other ways that you know to administer these drugs?
No, there are some medications that are dissolvable, but those are difficult to use. Really, in the absence of an intramuscular or IM formulation, there's no reasonable approach at this point other than forced medications, as noted in my earlier testimony.
Okay.
Can you explain why there are not any less intrusive methods to restore competency? Not that I'm incompetent at all.
And Dr. Linsky, I think you mentioned early on him refusing to eat and drink.
You dry celled me.
Is there, where do you think the best place for Mr. Smith is to be treated?
The most appropriate and safest place for him would be Arizona State Hospital, because as a hospital, they would have access to resources not available at a community jail. One of the reasons that he had returned as quickly as he had was that the jail administrator and the nursing staff were concerned for his safety given his refusal to eat, and he would have had to been sent to a emergency room or a hospital to be force-fed by NG tube or nasogastro tube. And so Arizona State Hospital would be better equipped to deal with the complexity of an individual who's refusing food.
Okay.
Religiously fasting. I wasn't refusing.
And so you don't have the ability to do that in Yavapai Restoration and Competency Program,
Correct.
but you are familiar with the state hospital and their facilities there.
Yes, I was there last perhaps 4 years ago. It was right after COVID started, so maybe 2021, 2022, and they were able to proceed with these types of treatments. I have not reviewed their practices or their behaviors since, but I have not heard of any changes. So my clinical safe presumption would be yes, as a hospital, they would have the capacity to treat him.
And that medical recommendation you provided as well earlier for the prescriptions, they'd be able to follow that as well.
Correct.
In just a moment, Your Honor. And so based finally on your opinion, Doctor, that that regimen that you provided earlier is the medically appropriate course of action for Mr. Smith?
Yes, it is within a reasonable degree of clinical certainty that I would recommend that to the court as the most humane and appropriate medical treatment for this individual.
And that would likely render him competent?
Yes, there's a reasonable likelihood within clinical expectation that he would be restored to competency with this medication regimen.
No further questions, Your Honor.
I think you cross-examination.
Does that mean he would still cooperate with his counsel or cooperate with the court system?
I do apologize. Can you rephrase the question?
You indicated that this medication you believe within a reasonable degree of medical certainty would render him competent. Does that mean that he then would cooperate with either his defense counsel or the judge or the court system?
Correct, yes. The expectation would be that as his psychosis improves, the psychosis being the barrier to ability to engage, he should be able to engage with the court as it relates to working with his defense counsel and working with the judge in terms of understanding the reality of the situation once this psychosis improves.
And I guess my question, not that it should be, but would he?
Would he implies an element of choice? He certainly would have the capacity to do so. Whether or not he would choose to do so is separate from competency, I think.
You're familiar with, I'm sorry, you're familiar with Mr. Smith, correct?
Correct.
My understanding is back on October 12th of 2023, you met with him and conducted an evaluation, correct?
Yes, sir.
And during that evaluation at that time, he cooperated with you, talked to you, correct?
Yes.
And at that point, I believe you authored a report on October 16th of 2023, finding that Mr. Smith was competent.
Correct.
You then again met with him on April 16th of 2025, so a little under a couple years later, based on some factors, to once again meet and evaluate with him, correct?
Correct.
You said I was not responding to internal stimuli.
And you met with him, talked with him, and at that point, you came back with a different evaluation that he was incompetent.
Correct.
And you would agree with me, competency is fluid.
Correct.
All right. April 16th of 2025, when you met with him, you were able to have a discussion with him. Is that accurate?
Yes.
Have you been able to have any meaningful discussion with him since that date?
I have only tried on one occasion, which was in January of this year, and I was not able to communicate with him by his own unwillingness to participate with me.
Well, obviously that was, well, let me ask you this. He was brought to the Yavapai County Restoration Program and was there for about between 5 and 6 days, correct?
Yes.
And during that time, there was medication that had been prescribed for him, correct?
Correct.
And he did not take it at that time.
Correct.
During that time, you indicated he was uncomfortable there. He didn't want to be there.
Correct.
And I think you even said it was not a place he was comfortable at.
Correct.
Right. During these 5 days, again, your understanding was that he did not eat and at least appeared to not drink at all.
You cut off my water.
Until day 3, he did not drink, to the best of my knowledge, and I don't believe he ate the entire time he was there.
Okay. And because of the concern for his medical condition, Yavapai County, the detention officers of the jail, really didn't want to deal with him anymore and transferred him back to Coconino County. Is that accurate?
What was known to me was not necessarily a desire not to deal with him, but a concern that they would need to transfer him to a hospital to be force-fed which they weren't sure exactly how to do. So I don't know if it was a level of comfort, but it was a level of familiarity or awareness of how to safely treat them.
Okay. So Mr. Smith was not sent to the hospital, but was sent back to Coconino County.
Correct.
All right. During that 5 to 6 days of adjustment period for Mr. Smith, again, he never took any medication, correct?
Correct.
But he was only there 5 or 6 days.
Correct.
Had he originally been sent to the Arizona State Hospital, again, assuming this issue with hunger and water was affecting him health-wise, the Arizona State Hospital could have dealt with the medical issues right there.
Yes. Per my understanding of their licensure and facilities, they could have, yes.
And in fact, that's why you're recommending he's going to the Arizona State Hospital this time, is if that occurs again, your belief is, and your understanding is, they could deal with the medical issue.
Correct.
Once that medical issue is dealt with, then there would still be time at the Arizona State Hospital to let Mr. Smith get comfortable in his surroundings, if possible,
Yes.
and give him additional time to voluntarily take the medication.
Possibly, yes.
Okay, again,
My religious beliefs to take the religion. I
again,
have vested religious interest in not taking medication.
when people are transferred to either a different facility, depending on their mental health conditions, depending on a number of factors, it takes them a while to get used to that situation, does it not?
That would be consistent with my observation and experience, yes.
Okay. And again, Mr. Smith was only there for 5 or 6 days at the Arizona Restoration Treatment Program, correct?
Correct.
You don't know, well, do you know, had he been there a little longer, if he would have been able to feel a little more comfortable in that situation?
I don't know if he would have or wouldn't have. That would be speculative on my part.
Okay, and again, that because of the medical concern, there was never an opportunity for that to occur.
Correct.
Whereas at the Arizona State Hospital, if he's sent there this time, there is at least the opportunity, if there's a medical issue, to deal with that before he is forcefully medicated, correct?
Yes.
Okay. I mean, obviously, you would agree with me. Well, you know, Mr. Smith, in your dealings with Mr. Smith, you understand that medication, forced medication to him would be something he's adamant against.
Correct.
Religious reasons.
I'm sorry?
Religious reasons.
Was that a yes?
Director of the International De-Vaccination Rescue Mission, and I'm against pharmaceutical medication. I have a First Amendment free exercise right against medication.
Is that a yes, doctor? I didn't hear you. I'm sorry.
I apologize. I was listening to Mr. Smith. Could you ask the question again, just so I can answer correctly?
Your knowledge and understanding in dealings with Mr. Smith is that forced medication would be something he is adamantly against.
That is correct. I agree with that observation.
Okay. And given the severity of forced medication, would you agree it's best to give him some time to get accustomed to the surroundings he's in longer than the 5 or 6 days he was at Yavapai County Restoration Program?
I guess if that's a hard to answer yes or no, if I may expand on it. Given his intense opposition, I cannot speculate that he would likely agree to medications no matter how comfortable he were in a situation. He appears to be very comfortable at the jail here in Coconino County, yet I communicated with the psychiatric provider there, Summer Wolf, and he has consistently refused medications at the jail here where he is quite comfortable. So I would speculate that even in a different setting where he gained comfort, he would not agree to medications.
But obviously that's speculation. We don't know until he's placed at the Arizona State Hospital and given that opportunity to become comfortable in that situation.
I cannot know with absolute certainty. You're correct.
Okay.
Why won't voluntary behavioural compliance be considered as a less intrusive means to restore competence?
And certainly 5 to 6 days, it'd be a longer period of time would be more beneficial to see if he becomes comfortable than 5 to 6 days.
I think time certainly would increase with a greater likelihood of comfort in any situation, yes.
Along with the the diagnosis of the schizo, on the schizo spectrum and for the delusion disorder, there has been diagnosis of some type of personality disorder as well, correct?
There has been mentioned in multiple reports of evidence of a personality disorder consistent with either paranoid or narcissistic type.
And that disorder also, let's assume Mr. Smith is regained competency, that disorder also may have him in a situation where he's still not cooperating with counsel or the court system, regardless of his competency, correct?
It's possible, though personality disorders themselves typically don't correlate with incompetency, but it's, again, I suppose you could argue that anything is possible. So yes, it is possible.
With regard to the medication that you're recommending to Mr. Smith, for Mr. Smith himself, you indicated that it is your belief that it is in his best, did you say medical, for him medically?
To adhere to the medications, yes, that is the most appropriate medical treatment would be to be adherent with the medications to treat the psychosis.
With regard to the concern for side effects, isn't it important to know some of his medical history and medical background as well?
That would be ideal. We did ask him about his medical background previously, and I do have that documented here, if I may reference my report, based on what he had shared with us. He had referenced medical history was that he had denied any medical issues or concerns and notes he feels healthy, though he comments at one point that he had syphilis and had cured himself, though there is not lab testing that supported that, and he did not report or demonstrate the presence of any type of comorbid medical condition.
And that stems from a conversation you had with him when?
I spoke with him twice on this, once in 2023 and again in 2025. So two separate conversations, 3 years ago and 1 year ago.
Okay, but there's no further update from Mr. Smith himself since you spoke to him a year ago?
Correct.
Your Honor, if I could have 1 minute, please.
Go ahead.
Why not electroconvulsive therapy? Why not use electroconvulsive therapy on me instead of pharmaceuticals? If I'm so incompetent, why not use ECT? Why drug me? My religion does not prohibit the use of electricity into the central nervous system. It only prohibits the use of pharmaceuticals. Why?
You did indicate that there's a less intrusive medication than Halidol, correct?
In terms of less likely to cause side effects, yes.
Actually, there were 3 or 4 different
Yes, so multiple medications that would have a lower risk profile than Haldol.
And you're concerned with those, that those are in pill form, and that's something that you're concerned that Mr. Smith would not agree to take?
Correct.
Why not send me to Sedona and use wide frequencies on me?
So it's your opinion that Mr. Smith should be transferred at this point to the Arizona State Hospital in case there's a medical issue that would have to be dealt with, as there was at the Yavapai County Restoration Program, correct?
Yes.
Had he been placed there the first time instead of Yavapai County Restoration Program, the hospital, you believe, could have dealt with the medical issues at that point?
Yes.
And then we, the court system, would have been able to see if he had at least become more comfortable in that setting to see if at some point he would have voluntarily taken medication, correct?
Yes.
Judge, that's all I have.
All right, thank you. Redirect.
May I communicate with my psychiatrist now?
Thank you, Your Honor.
Communicate with my psychiatrist.
Not at this time, Mr. Smith. Your attorney gets to ask the questions here.
What can I ask
And
him?
when Mr. Smith was originally...
He said that I was not responding to internal stimuli and I was not hallucinating, and now he's flip-flopping. This is perjury by inconsistent statements, Mr. Steinlage.
And Dr.
Go ahead,
Linsky,
Mr. Noble.
when Mr. Smith first went to the Yavapai Restoration and Competency Facility, you weren't aware of any medical issues at that time.
Correct.
Specifically, that needs to be medical interventions for hunger strikes or issues for water.
It's not a hunger strike. It's a religious
Correct.
fast.
Mr. Smith, you have to respect the process and allow Mr. Noble to ask the questions. You can't interrupt him in the middle of him trying to ask questions of the doctor. Go ahead, Mr. Noble.
I apologize, Mr. Steinlage.
Thank you. And Mr. Parzik on cross talked about a little bit about comfort, and I think you touched on it just a little bit. But he has been at the Coconino County Jail for upwards of 2 years. Is that correct? Or close to 2 years?
Yes, I believe he came to us in August of 2023. So that would be about 2.5 years.
And during that time, he didn't take any medication?
Correct.
And on cross-examination, you discussed the personality disorder. However, the meds that you are prescribing are treating the delusional disorder. Is that correct?
Correct.
And the delusional disorder is not the barrier here. Is that my correct understanding?
The delusional disorder is the barrier to competency.
And I misspoke.
Not
So
the
and not the personality disorder.
Correct.
How am I delusional? You said in your 2023 report you'd seen a video of my car on fire, and then in 2025 at the June 24th hearing, you stated that I was deluded about people trying to target me, Mr. Linsky.
Right. Your next question, Mr. Noble.
Thank you, Your Honor. I'm just referring to my notes.
Related to perjury, Mr. Steinlage?
Nothing further, Your Honor.
Do you have any further questions, Mr. Parzik?
No, thank you, Your Honor.
Dr. Linsky, can you speak to, I'm sure you're aware that the Arizona State Hospital has all but closed down their restoration of competency program?
I know that they've limited their beds. I think someone had referenced that they had decreased to 2 beds, which I have not had verified. That was just verbally reported to me by a coworker. That's the extent of my understanding of how they've limited their programming, yes.
That's the court's understanding as well, is that at around the first of the year, they limited their beds in the program to just 2. Do you know how many beds they had previously?
I believe they had 16, based on my recollection from approximately 3 years ago. I know many years ago they had upwards of 30, and then it was a reduction to 16, and then someone had just referenced 2 beds. And again, that has not been verified or substantiated, but that seems to be the consistent number of beds that's been told to me by several individuals.
All right, thank you. And just to be very, very clear, you do believe it's substantially likely that Mr. Smith would be restored to competency with the use of medications?
Medications will likely restore him to competency relative to treating the psychotic disorder, yes.
And it's substantially unlikely that the side effects would significantly impair his ability to assist in his defense?
Correct.
And are there any alternative, less intrusive treatments, not just medications, that could possibly achieve or have a likelihood of achieving substantially the same results?
I am not aware of any, no. So I would say no, I'm not aware of any medically that would be likely to effectively treat his psychotic disorder.
You said I had a psychotic disorder in either of your 2 previous reports, Linsky. You said I had no disorders at all in your 2023 report. In your 2025 report, you said that I had had delusional disorder, not psychotic disorder.
And Dr.
Linsky, I overheard him. I don't know if I can respond, but a delusional disorder is a type of psychotic disorder.
However, am I delusional when there's evidence that Adam Keith Zickerman is trying to say that Samuel Rappley Bateman is having sex with his 9-year-old and 12-year-old wives, and you said that I was delusional for saying that Adam Keith Zickerman was a child sex normalization activist, Mr. Linsky? I'm not delusional at all. You're committing perjury, aren't you?
I'm going to stop this. The court's asking the questions currently. And I know that you testified specifically that it was medically appropriate to medicate Mr. Smith specifically with Haldol and Cogentin. Could you take the court through again why that is from a medical perspective as a doctor?
Yes. So psychosis appears to be rooted in an imbalance of neurotransmitters, in particular dopamine being a neurotransmitter that, when at higher levels, seems to cause delusions, hallucinations, disorganized speech, disorganized behavior. In Mr. Smith's case, specifically, he has delusional disorder, which is a subset of psychosis. Medications such as Haldol have consistently been shown by their acting on dopamine receptors in the temporal lobe to decrease the intensity of delusions in this case. They can also help with hallucinations, disorganized thoughts, and disorganized behavior, which isn't the case here. Using Haldol as the primary medication correlates with improvement in psychosis, which leads to an individual to be better able to understand the reality of the situation and, by extension, work with their defense attorney to defend themselves against serious charges. The other medications, the Cogentin in particular, assists because it tends to greatly decrease the likelihood of any uncomfortable side effects from the Haldol, such as muscle stiffness or such as a sense of uneasiness. The lorazepam or Ativan helps because it tends to make the Haldol more effective at lower doses, thus minimizing the need for higher doses of Haldol. It also tends to help with sleep. Generally, sleep is seen as a very restorative experience and can help the brain in general. So the combination of the Haldol, primarily for the psychosis, with the other medications to treat side effects and augment the efficacy or effectiveness of it, would be the most reasonable approach, because all of these medications additionally are available as an oral as well as an injectable form. And if the individual declines the oral, they're given injectable medication to ensure they are receiving appropriate medications for their psychotic disorder.
Thank you. And the court's aware that ordinarily it's the practice to titrate the individual on these medications. Do I understand correctly that if the court were to order it, that you would begin with 5 milligrams of Haldol
Yeah.
2 times per day, and then possibly titrate up from that to a maximum of a total amount of 20 or 40 milligrams per day?
Thank you. Yes, so the general approach would be to start with Haldol at a dose of 5 milligrams in the evening for 2 or 3 days, advancing to 5 milligrams twice a day, then 5 in the morning, 10 at night, and then possibly 10 twice a day as a typical dose. That is the dose limit typically for an illness such as schizophrenia. Delusional disorder typically is responsive to higher doses, so the maximum dose that would typically be attempted to treat this disorder would be 40 milligrams, 20 milligrams twice a day. There would be opportunity to use much lower doses. I think we all recognize the higher the dose, the greater the likelihood of side effects, both transient and serious. So we would take advantage of time to use lower doses for longer periods instead of trying to go too quickly to a high dose, which is more likely to cause side effects. So yes, a titration would be used with a maximum dose of a delusional disorder being 40 milligrams a day, but a hopeful dose being 20 milligrams or less a day.
Dr. Linsky, how do you
So
explain your
the maximum amount, if I understand correctly, the maximum amount you would propose using there would be up to 20 total milligrams per day, or would it sometimes go up to 40?
40 milligrams for delusional disorder.
Okay, thank you. And then for the Cogentin, it's 1 milligram 2 times per day. Is there a titration, or is that pretty standard that that's the amount?
Typically, it's increased. If someone were to be on 40 milligrams a day, such as 20 twice a day, appropriate Cogentin dose would be 2 milligrams twice a day. So if the court is looking for a dose range, a maximum dose of 4 milligrams a day would correlate with a maximum dose of 40 milligrams a day of Haldol should those highest levels be approached. But usually for 10 milligrams twice a day, common dosing of cogentin would be 1 milligram twice a day.
All right, and then that takes me to the lorazepam. If I remember correctly, for that, it's generally a small dosage, and that doesn't
Correct.
change.
Correct. Typically, the maximum dose is 2 milligrams a day because it's typically only given at nighttime in this case, and doses above 2 milligrams at a single dose generally are not recommended, even for a young, healthy person such as Mr. Smith.
All right, thank you.
Doesn't lorazepam cause long-term memory loss, Dr. Linsky? Doesn't lorazepam cause long-term memory loss? Can that long-term memory loss affect my ability to recollect? And would this not thusly affect the fairness of the trial?
I'll allow you to speak to this potential side effects of lorazepam, Dr. Linsky.
Thank you, Mr. Steinlage.
Okay. Yeah, if the question just wants to be posed so I can answer within the scope of the court's interest, I'd be happy to answer questions.
The question is,
I think the question...
the long-term memory of the lorazepam, and would that effect of long-term memory affect the fairness of the trial, Dr. Linsky?
Were you able to get that, Dr.
Okay, so, yes, I did. So I just want to make sure, I know I responded to one of Mr. Smith's questions earlier and I was asked not to, so I just wanted to clarify at this point it was okay. So Mr. Smith, yes, lorazepam, there were some older studies that demonstrated lorazepam had a risk of long-term memory loss. Those studies appear to have been found to be inaccurate for the long-term use. However, for short-term use, lorazepam in the short term can impair memory functioning as it relates to putting down new memories and recalling things. Short-term memory and cognitive function can be impacted. One of the reasons that we give it only at nighttime is because by the time the next day comes around, people generally do not have any memory impairments. If someone were to take lorazepam and learn new information, that memory would be much harder to retrieve. However, if someone takes lorazepam in the evening and they are presented information the following day, the evidence does not support that there's memory impairments in that case based on my understanding. So while there had been some studies about 5 to 6 years ago suggesting there was long-term memory impairments with lorazepam, those studies have not held up to scrutiny and they do not appear to be accurate based on the best data available to me.
All right.
Think about the
Thank you.
studies from the Schizophrenia Bulletin, Volume 41, Issue 5, that states, this review evaluates antipsychotic medication and psychotherapy effectiveness and concludes that delusional disorder is challenging to treat successfully with medications alone. You, however, have stated that the delusional disorder, if I even had it, could be treated with medication. But the Schizophrenia Bulletin disagrees with you, Dr. Linsky. Why are you going against peer-reviewed science?
The court has asked all the questions it had. Did either counsel have any further questions that either of you wish to ask? I just want to make sure while we have Dr. Linsky, everyone has their opportunity.
None from the state.
No, Your Honor.
All right. May Dr. Linsky be excused?
Yes, Your Honor. Thank you.
No objection.
You are excused at this time, Dr. Linsky.
Thank you. Thank you all.
All right. At this time, we'll proceed to argument.
And thank you, Your Honor. The state is ready for argument. The state has no other witnesses either for the record. So the state does ask the court to order the defendant to be medicated in this case. I think, like the court mentioned earlier, that there are those 4 prongs under cell. It doesn't appear that there's a material dispute, at least as the first prong, that there is an important government interest. Looking at the charged offenses here, it is sufficiently serious. That there is that government interest. The court focuses at the maximum penalty under the law, and looking at what Mr. Smith is possibly looking at, he's looking at 32 years of incarceration. Also looking at 2 of these offenses, at least one of them is statutorily a serious offense, that being the kidnapping. I think this attempted murder, second-degree murder is also, but I definitely know that the kidnapping is as well. So there is that sufficient government interest. There's nothing really to lessen that interest as well. Defendant has to look at 32 years, and so looking at the time needed to restore.
Mr. Smith, you can't interrupt. It's not even your side's turn to speak right now. Go ahead, Mr. You're not objecting. You're just speaking over him. That's not what an objection is.
Time needed to restore is Dr. Linsky at previous hearings mentioned that he would be restored within a normal time frame, so the 32 years is well within that time. Also, civil commitment is not a sufficient remedy here as well. That'd be Title 36. And so Mr. Smith has been in custody for roughly, as Dr. Linsky said, 2.5 years, but there is still some significant, much more time that could potentially be over his head. So I think as to the first prong, there is an important government interest based on the seriousness of just looking at the seriousness of these charges without looking at the facts of these charges, which in and of themselves are extremely concerning and alarming to the state. But just looking at the charges alone, there is an important governmental interest. Dr. Linsky testified here that the involuntary medication will further that state's interest, that being holding the defendant accountable for these charges, whether he decides to go to trial or take a plea. And so involuntary medication, Dr. Linsky indicated that is likely to render him competent, and ultimately that the benefits outweighed any of those side effects. And he does acknowledge there are side effects, but those are very low and very rare. And he does prescribe other medications to mitigate those side effects as well. And so I think specifically as to the Haldol, there is the concern of tremors or tardive dyskinesia. Tardive dyskinesia, as you mentioned, is very low, but doesn't really onset until after 5 years of medication. And so he also discussed the possibility of memory as it applies to lorazepam. But like he said when the court asked questions about it, that those are largely mitigated when taken at night. And so, the concerns of memory loss were based on older studies as well that no longer appear to be the current data. And so there are very low side effects, and so the medication will further that state interest. And so there are basically that the involuntary medication is necessary to further the state interest, meaning that there is no other less intrusive means. And so the court asked, I think specifically, are there any other intrusive means other than medication? And Dr. Linsky said no. Medication basically is the only way to do it. But then also, he's attempted voluntary compliance with Mr. Smith at the Yavapai Restoration to Competency Program, and he didn't want to take the medication. But furthermore, there's also over 2 years of data of him not wanting to take medication or not wanting to engage with medication. So he's had ample opportunity to take the medication no matter where he is. And it's not a question of comfort, as defense counsel highlights, but it's a question of just not wanting to take the medication. And Dr. Linsky mentioned that the psychotic disorder, the delusional disorder, is the primary barrier to him being found competent. And so by treating that, he likely will be determined to be competent and can work with his counsel. So Dr. Linsky did mention that the administration of these medications is medically appropriate and in the patient's best interest because it allowed him to participate in the process and diminish these delusions in his way of thinking. And so there are no real side effects that will affect his success. So the state does ask to order that the defendant be required to take those medications, specifically with the specific range that Dr. Linsky discussed, whether titration of the medications, but the maximum range of the Haldol would be 40 milligrams. The Cogentin, also I believe the maximum range was 8 milligrams, and then also the lorazepam as well. So the state does ask the court to order those 3 medications. Additionally, the state does request that the court order the defendant to go to the state hospital because that appears that it is the best place for a defendant to go because treating defendant at Yavapai and then interrupting his treatment to go to the hospital for food or water would complicate the process, and so the state does think that the state hospital is the most appropriate, and the state asks the court to order that as well. Thank you.
Excuse me, the United States v. Rosman, 446.
Does the state have any idea how long the wait for the state hospital is presently? Or if Ms. Chernello is, if anybody happens to know that, if they would provide that information to the court. I just don't know if anyone does, but Do you have any idea, Mr. Trinello?
I don't, Your Honor, but I can reach out.
Yeah, okay. I'm just going to, and I'm going to turn to you, Mr. Parzak, but the court's aware that I had cases that were already ordered to the Arizona State Hospital last year before they changed it to 2 beds. And those individuals had already waited for months to try to get into the state hospital before they reduced it down to just the 2 beds. The court in each of the cases that I had that were in that situation, ultimately, I was asked by defense counsel ultimately to change the court's orders to give their client the opportunity to go to Yavapai because of the incredible amount of time people were waiting just to get there. And actually, no one got there once they changed it to the 2 beds. So I haven't had anyone go to the state hospital since they made that change. And I've been asked specifically by counsel to have people at least get the opportunity at Yavapai first, because the entire process at Yavapai would likely be over, whatever its outcome, before the waiting time to go to the state hospital would even take place. I know at least, I can't speak for both of the beds, but I know that Coconino County currently has someone taking up one of those beds right now and has been there for, I think, approximately a year, that individual. So I just want to share that information with the attorneys to make sure everybody's eyes are open to what the court's aware of in terms of people waiting just phenomenally long times and feeling like they are just waiting forever for one of those 2 beds. When you're competing for just 2 beds, the wait could be astronomical. Mr. Parzak.
Judge, obviously, with regard to the 4 factors, I'm going to focus on just 2 of them. The first factor, the important governmental interests are at stake. I would agree with the state that the charge is sufficiently serious enough under that portion of the prong. However, Judge, I do believe there are special circumstances that lessen the governmental interest. In fact, Mr. Noble already commented on one. Mr. Smith has been in custody already 2.5 years. The second one, Judge, and I'm going to ask Mr. Noble to correct me if I'm wrong, because this occurred prior to my being counsel, is that there had been an offer made by the state that effectively would have given Mr. Smith the opportunity to receive credit for time served or close to that. And again, that has been relayed to me from prior counsel. If that's not the fact, I will stand corrected. But I think that is something that, if that is the fact, that does lessen that special. That is a special circumstance that lessens the governmental interest. So again, if I'm wrong, Mr. Noble can correct me, but that's my understanding. Finally, Judge, I want to focus on the third prong. Involuntary medication is necessary to further these interests. There's not less intrusive treatments or means. There still are less intrusive means, Judge, and that's basically the ability for Mr. Smith to get comfortable in his environment to voluntarily take that medication. Because what we're talking about is involuntarily medicating Mr. Smith. He only had 5 to 6 days at the Arizona State Hospital. He was not comfortable there as Dr. I'm sorry, Yavapai, thank you, Mr. Smith. At the Yavapai County Restoration Program, Dr. Linsky testified he was not comfortable there. That is not sufficient time to give him that opportunity to get comfortable there. Obviously, for medical reasons, he was transported to the hospital. Dr. Linsky suggested it would be better off at the Arizona State Hospital where that can take place. And I understand, and I don't dispute what you're saying about the 2 beds and the time frame, but that's not a factor that the court should consider. Are there less intrusive treatments or means? Yes, there are. It's at the Arizona State Hospital where he could get comfortable before you involuntarily have somebody inject him with a medication that he doesn't want to take. Let him get comfortable there. And once he gets comfortable, see if he agrees to that. If he doesn't, once there's a comfort level or sufficient time for that to reach, then we're right back to where we are. But again, I don't believe the fact that there's a small number of beds, whether it be cost reasons, other reasons, as a factor the court can consider. With regard to the time it may take to get them there, again, I also would dispute that that's a factor the court can consider. And in fact, I think the court's well aware, Mr. Smith has no problem waiting for that time. He's done it already. That's not going to be an issue with Mr. Smith. I'd be shocked if Mr. Smith comes forward and says, hey, Judge, I don't want to wait anymore. Send me back to Yavapai County. So I don't think that's one. It should be a factor the court should consider. And even if the court does, in Mr. Smith's case, it's not a factor that really is going to matter. So I believe there are still potential less intrusive means that this court system, that the restoration program system has not gone through yet before we forcefully medicate Mr. Smith. For that reason, Judge, I would ask that certainly reorder him to the restoration program, this time at the Arizona State Hospital. I would ask the court to withhold ordering involuntary medication until we see what happens when he gets comfortable at the Arizona State Hospital. With regard to the fact that he hadn't taken medication, we had the chance to do that while at Coconino County facility. Judge, that wasn't court ordered. That's not a factor that court consider. Whether he voluntarily takes medication while he's in custody when it's not court ordered isn't something the court should consider. So for these reasons, Judge, I would object. It has to be by clear and convincing evidence that that there are not less intrusive treatments or means at this point. They still exist, Judge, and that's at the Arizona State Hospital. So for that reason, I would object to any involuntary medication ordered at this time.
I also object with Cells Prong 1 under the Rodman case, who also suffered from schizoaffective disorder and delusional disorder. Say Hardy is correct, and I do have schizoaffective disorder and delusional disorder, which I don't. There would be the grounds to go and commit me, which would lessen the state's interests in trying to involuntarily medicate me. Furthermore, there is also grounds to not medicate on religious reasons under State v. Harris. And this man was a Jehovah's Witness. I am the director of the International Devaccination Rescue Mission. I completely prohibit pharmaceutical medicines. 1.2 million Americans were killed by Bolesky's mRNA injection. I am absolutely diametrically opposed to all pharmaceutical medicine. And my religious interests are just as valid as my liberty interests.
And Judge, the state's going to object right now.
And Frank Court was letting Mr. Smith speak because much of what he's saying is entirely in conflict with what his attorney is stating. He's making it very clear to the court that there's no basis under which he's going to be willing to take medications. As he just stated here in the courtroom, he's diametrically opposed to taking medications under any circumstances. So frankly, the court's just letting him make that statement because it weighs on the court's determinations and what to do here. So with that, the objection is sustained, but that's why the court is letting him go on about those details. Go ahead, Mr. Noble.
And thank you. I think the record is more than ample at this moment, though, because court defendant's not going to follow any court orders because when asked to not talk during this hearing, he continued to talk. I know the court pointed out that he said he was defendant was diametrically opposed to taking medication. And so I think that does help in showing why forced medication is appropriate. Mr. Parzak focused on 2 points in his response, and so the state is going to talk about the second one he talked about is getting comfortable at wherever he is, the state hospital or Yavapai Restoration Facility. Defendant has had the opportunity to go to the state hospital and take medication there. He's been there for 5 or 6 days. Basically decided to refuse to eat and drink. Yavapai Restoration Facility wasn't able to handle him, so they had to send him back in the time being because they weren't sure what to do because he wasn't taking the medication. Furthermore, he's been at the Coconino County Detention Facility for 2.5 years. And so he has had the opportunity to take medications during this entire time, and he has not taken it as well. So I think there has been ample opportunity for him to take the medication. Mr. Parzak does talk about the prong 1, specifically looking at time served. I don't think the plea is something that the court can take into consideration as one of the elements, because ultimately, in offering a plea agreement, the defendant is admitting guilt, whether it's a felony, undesignated, or a misdemeanor. That is something that the state does give a substantial benefit to in cases, and whether it's a felony conviction, that's something that the state takes seriously, or it's an undesignated where the parties can argue it. And so, yes, so the state does not think that that's an appropriate thing that the court can take into consideration. Even as this case has progressed, there's been additional concerns by the state of the defendant's conduct, and but I just want to point out that the point that Mr. Parzik pointed out should not be taken into consideration. If it is, given little weight, because there is substantial time the defendant is looking at time in custody. And so the state does think that there's an important government interest in Mr. Smith being medicated here because of the seriousness of his conduct in this case. And so the state does ask the court to order the medication for the Haldol, the Cogentin, and the lorazepam in this case, because there is that important government interest. Mr. Smith, has by his conduct here at this hearing and several other hearings, shows that he won't follow court orders and is diametrically opposed, as the court pointed out, to taking medication. So the state does ask the court to find that the factors have been met here by clear and convincing evidence. Thank you.
Excuse me, but under the motion to remand to the grand jury filed by
I'm sorry,
on 8th November,
Mr.
I'd like
Smith.
to suspend this motion to remand to challenge the seriousness of the offences, please.
At this time, the court's going to put its findings on the record, Mr. Smith. The court notes again, in making the determination, the court recognizes, Mr. Smith, that you have a significant constitutionally protected liberty interest in avoiding unwanted administration of antipsychotic drugs. That's why there's such a serious standard that's created here under the Cell case in the U.S. federal court, and then that's been adopted here in Arizona under the Kottner case. The court, in conducting these hearings, is very specific as to what the court will consider. The court only will consider medical testimony from a doctor who actually has the training and ability to actually prescribe a person medications and to give medical testimony to the court. The court did hear medical testimony from Dr. Linsky. He is a person that's qualified to do that. Dr. Stewart, for instance, at the and his testimony would be insufficient here, is all I was going to tell you, because he doesn't have that same training and ability to act as a psychiatrist. The court goes through the four factors very specifically in these cases, because the court recognizes that what it's asked to do in a case such as this is very significant, and it's against your will. And I take that very seriously. But the court has its duty to go through and make its findings based upon what's presented to it. And I can't ignore that duty just because you object to it and don't want that to happen. The first factor is whether you cannot. The first factor is whether the charged offense is sufficiently serious to establish an important governmental interest, and if so, then the court looks at whether or not there are special circumstances that lessen the government's interest. It's not sufficient to just establish a general interest that serious offenses are prosecuted. In determining whether the offense is sufficiently serious, the court's required to consider your prior criminal history, of which the court is not aware of anything of significance. Secondly, the court has to consider the potential length of the prison term and the charges under the charges that you have. Here, the calculation by the state in its motion, which the court agrees with, comes out to over 3 decades, 32.75 years if you were to get the consecutive sentences at the aggravated terms. It was unsuccessful, that's right. And the court considers that's quite a serious sentence. Frankly, from the court's perspective, the specific conduct alleged is quite alarming and quite serious. Frankly, the specific conduct alleged in the case, where there's an allegation of the victim being bound and gagged, and then the court finds the specific conduct alleged even more alarming, frankly, than the charges that you have. And the court just notes that. There's no doubt that the offenses qualify as serious offenses that establish a governmental interest. When looking at the special circumstances that reduce that, the court doesn't believe that there's a realistic possibility of civil commitment proceedings. The court notes the need to restore you to competency is significant so that your case can proceed. The court notes that you've been in custody for quite a long time, 2.5 years approximately, awaiting a resolution of your case. There have been very significant delays. Many of those, frankly, have been based upon your own actions in the case and with your attorneys, and it's been difficult to move forward in the case. But the court believes that you need to have your day in court sooner than later, and this is part of that. The court also believes that the constitutional requirements for you to have a fair trial, where if you ultimately get convicted, you need to be competent, obviously, at the time that that's going on. I don't believe that that weighs against the state's special or the state's important governmental interest. In looking at factors 2 through 4, there are a number of questions that the court generally looks at that are informative to all of those determinations. The first is, what are the specific drugs that are involved? And specifically, there's 3 drugs, as Dr. Linsky outlined here: Haldol, Cogentin, and lorazepam are the 3 medications that are prescribed. The court notes that while Dr. Linsky is recommending those specific medications and at the specific ranges that he testified to, those are his particular recommendations and prescriptions that he would give Mr. Smith if he were to be treated at the Yavapai Restoration and Competency Program. The court has no idea what medications would actually be prescribed to Mr. Smith if he were to be ordered to go to the Arizona State Hospital. The court has had issues where the court, a doctor, just because the court says treat the person with this, I think is going to be very resistant to doing that if they don't believe that that's what's in the medically most appropriate for the particular defendant or client that they're, or patient that they're dealing with. That would be specific to Dr. Linsky's recommendation if he were treated at Yavapai. I don't know what the doctor that worked with Mr. Smith at the Arizona State Hospital would prescribe to him. The specific medications that are prescribed here, Dr. Linsky took us through exactly why Haldol is recommended, as it can be both oral and can be injectable as well. And before that reason, it's typically used. But then hopefully if someone gains either competency or starts to stabilize, do better, that they might become engaged and be willing to use other medications, which he indicated are preferable, like Risperdal and some of the others that he named. But Dr. Linsky also explained that for that reason, since Haldol is an older medication that's been used for approximately 50 years in the treatment of these kinds of mental health diagnoses, that we've over time come to use medications like Cogentin to offset some of the known side effects, specifically the most common one being stiffness and restlessness, and it being prophylactic to avoid that. And then also the use of lorazepam at night to avoid the memory issues that were brought up by Mr. Smith, and to also make a smaller amount of Haldol effective. so that the individual doesn't have to take a very large dose of Haldol to get the same benefit from that medication. The court just notes that the specific drugs and the plan is very specific and well thought out, and one that the court's frankly familiar with, having been in this same situation in other cases numerous times. The court notes that there are no specific anticipated side effects for Mr. Smith specifically.
My family can sue you out of house and home. Do you understand?
Is the third question is the administration of the drugs substantially unlikely to have side effects that will interfere significantly with Mr. Smith's ability to assist counsel. That's what Dr. Linsky specifically testified to, that the circumstances and the risks of the side effects are actually quite low, even the most serious side effects. In the number 4 is the medication substantially likely to render the defendant competent to stand trial? Dr. Linsky testified that it's not only substantially likely, it's substantially likely to occur in a short period of time as well. The court notes that Dr. Linsky didn't note any factors about Mr. Smith, specifically about his condition, age, or delusions that would I misspoke. Dr. Linsky did specifically talk to why Mr. Smith's specific delusional disorder is specifically appropriate, and that the treatment regimen and titration and limitations on that are specifically addressed to place it within the specific diagnosis of his delusional disorder. So when answering and looking at factor 2, keeping in mind all of those questions that feed into that, factor 2 asks whether forced medication will significantly further the state's interests, and the state must show first that it's substantially likely that the defendant will be restored to competency. Certainly that's the testimony that we heard from Dr. Linsky, and that it's substantially unlikely that the side effects will significantly impair Mr. Smith's ability to assist in his defense. The court also notes that the testimony of Dr. Linsky clearly established that as well. On factor 3, the court's required to address whether forced medication is necessary to further the state's interests, and whether any alternative, less intrusive treatments, not just medications, are likely to achieve substantially the same results. The court, from Dr. Linsky's testimony, the court is satisfied that medications are what is necessary to achieve competency, and that there aren't alternative, less intrusive treatments that are likely to achieve substantially the same results. This isn't a set of circumstances where Mr. Smith is likely to just get comfortable with the setting that he's in and then suddenly completely change his worldview and his views on medications and the position that he holds with the organization that he's describing. He's made it very clear all throughout his case, and the allegations in his case are that he was committing the crimes he's alleged of committing based upon his belief that the victim was forcing medication or causing harm to people by using vaccines. It's quite clear to the court that there's no likelihood of Mr. Smith voluntarily beginning to take medications in a different setting.
Right now, testifying about the cover-up and the mass murder.
Under factor 4,
Saying the same thing.
Under factor 4, the court has to make a determination as to whether or not the administration of the drugs is medically appropriate. This is why it's absolutely necessary for the court to hear from a doctor, because the court has to make a determination the administration of the drugs is in the patient's best medical interest, which is what the court has heard from Dr. Linsky.
What are you medicating for? Which one?
the defendant is, that it is medically appropriate to medicate Mr. Smith with the medications as outlined by Dr. Linsky. With that, the court's quite satisfied that the state has met its burden by clear and convincing evidence establishing each of the four factors under the cell test. The court does grant the state's motion in this case. The court is not going to disrupt and change course at this point. The court is going to order that Mr. Smith return to the Yavapai Restoration to Competency Program at this time, and that he will be overseen there where the specific medications that were recommended and prescribed to him by Dr. Linsky would also be provided to him again by the same doctor that is making that recommendation.
Linsky's blatant perjury. I'll see you in federal court, Steinlage.
That will be all in this matter.
The United States District Court for the state of Arizona. And
Thank you.
Explain why you allowed
Judge-
Dr. Pardy's perjurous conduct.
Judge, if I may, there's cases you cited, Kotner, C-O-T-N-E-R-B, Linsky, L-I-W-S-K-I, 243, Arizona 188. Another case, Wolf v. Kotke, K-O-T-T-K-E, 248, Arizona 319. Both of these cases are published decisions, and they came up on a special action. At this point, Judge, I'm going to request a stay in the proceedings before he is transferred for involuntary medication so that I can file a special action with regard to this matter. In the alternative, Judge, I'm sorry. Go ahead.
Just the second case, I don't think I cited that case that you.
You didn't. I said that. Yeah.
You did,
cited
okay.
one. The other one you cited was Cell.
Right.
The one I'm citing is Wolf v. Kotke. The Wolf v. Kotke and the Linsky case, or Kotner case, I think you referred to, both came up on special actions, which is what needs to be done in this case. So I'm requesting to stay in the proceedings so that I can file special action. In the alternative, and I understand the court's wanting to get this resolved, I'd ask the court that the court make this order and delay the order not to become effective until May 13th. That gives me 3 weeks to file something with the Court of Appeals, special action, to see if they accept jurisdiction or not. As this court is well aware, I'm number 6 or 7 attorney. It's going to take me a while to get all the materials together for this. So I would request either 1, stay in the proceedings, or 2, in the alternative, just make the order effective May 13th to give me that opportunity in that time.
You're liable
Its position.
Steinlage because of abuse of process.
Judge, for the record, the state does oppose the stay. This matter's been going on long enough, and Mr. Say wants the treatment to go as soon as possible.
Understood. I will take the second suggested course of action. The court will issue its orders. I'll have those out either today or tomorrow. I think I can get that done sooner than later. I will make it clear that the order at the outset of the order, I'll make it clear that the order becomes effective on May 13th to give defense counsel the opportunity to file anything it wishes challenging the court's determinations in the Court of Appeals.
You filed your motion to withdraw, Parzak. You don't represent me, and you never did.
Do I maybe I can find the clerk, just how I get a transcript or a copy of this proceeding, but I'll check with the staff on that. I would just ask for if there is a way to expedite all this, but I will check with the staff or clerk.
You're wasting your time at the Court of Appeals. They'll just get to decline to accept special access jurisdiction. I'm taking it to the federal court, Steinlage, and you're the defendant. Do you understand?
The court will order that the transcript from today's hearing be produced and provided to Mr. Parzak as quickly as possible. I don't really know what to do beyond that.
I want a copy, not him. He's given his motion to withdraw.
The state just asked for a copy as well. I didn't hear the question. If there was a question posed, sorry.
I don't think there was a question. I'm just ordering, just to try to speed the process. I'm ordering that the hearing be transcribed as expeditiously as possible and provided to the parties as quickly as possible.
Thank you, Judge.
All right, and that will be all.